So that was testimony from Gypsy just a little bit ago. And here's the thing. I'm a child welfare law specialist and deal with abuse and neglect almost every day in my private career. And part of what really gets to me in this case is there is no doubt that she is a victim. The mother was diagnosed with Munchausen's by proxy, and I'm not an expert, but I can tell you the basics, and that is child abuse by a caretaker. If you listen to her testimony and her outlining her abuse and that she was in a wheelchair since she was 8 years old, she doesn't know why the mother did it. She had cancer, seizures, glasses, hearing aids. All of this is child abuse, and so one of the things that I just want those viewing to keep in mind is that when it comes to Gypsy Blanchard, her trauma and everything that she's gone through forms her as a person and who she is. Now, that's just an aside. It does not justify killing someone, but certainly she has been a victim of child abuse. So now I'd like to bring in our special guest. Jennifer Schuster, criminal defense attorney, is joining us for legal analysis this afternoon. Thank you for joining us. How does the fact that she suffered abuse play into the defense for Nicholas, her boyfriend in this case?
Yeah, like you said, Ashley, there is no doubt that this young woman suffered tremendous abuse at the hands of her mother, but it was her trauma. It was her abuse. And I think what the defense is trying to do here is bootstrap that trauma and that abuse to Nicholas, associate them as closely as possible so the jury has sympathy for him through osmosis, via Gypsy's story here. But, I think it's problematic, though, because it's not his trauma. Sure, he heard about it from her, but it didn't happen directly to him.
Do you think it's enough to put reasonable doubt in the minds of at least one juror?
Maybe not reasonable doubt as it relates to first-degree murder, but I think they still have a problem when it comes to the lesser offenses here. The defense still really needs to convince these jurors. I mean, they don't have the burden of proof here, but I think a big part of their defense relies on the fact that he had this diminished mental capacity because he's on the autism spectrum. So, I mean, Gypsy explains why he had this motive to do it, but still the defense needs to pick up the slack and say, yes, but he also had this diminished mental capacity, and that's really what explains why he did it and why he should be exonerated, essentially, or at least if found guilty of a lesser offense.
So devil's advocate, if I'm thinking through the prosecution phase to get a conviction, and then if there's any conviction, the sentencing phase, because in Missouri, remember, and I know that you know this, but for those who are viewing, the penalty phase is decided by a jury and it has to be unanimous, and if it's not, then a judge does it. So why is her testimony even relevant when it comes to seeking a conviction by the prosecution? Would this testimony not be better presented in the penalty phase if that's reached?
Well, I think you're right. They do have to consider their strategy in light of the fact that this same jury will decide the sentence. But I think, her testimony is so compelling that I think it makes sense, or at least I can understand why the defense thinks, let's bring that out as soon as possible. Let's get this young woman's story out there so they can really understand what the defendant was thinking here.
So we're going to come back to you in a couple minutes about what you would have done as defense attorney, but I want to share breaking news in this case. So what we know is that there is a smell in the courtroom the judge was concerned about. So everyone has exited the courtroom. They're taking a break. We are going to show more testimony that was pre-recorded just a little bit ago in the last hour of Gypsy Blanchard, again testifying in the case of Missouri versus Nicholas. Go to John. Welcome back. There are lots of reasons that I love Law and Crime, and I am a trial nerd, but here's what's really fun for us. Kathy Russin, Law and Crime's own, is actually there covering the trial, and she said that she herself did smell something in the courtroom. That's why they've been on a recess, been on a break, maybe electrical, not sure what the smell was, but that's what it smelled like. So you just saw a picture, and they're showing the courtroom. They will be resuming. In the meantime, let's talk about some of the testimony that we've heard so far, and the other benefit to having Kathy Russin there is that she could tell us that she observed the two female jurors, let me rephrase that, two of the female jurors did not look at Gypsy during her direct examination by the defense so far. The other thing that is important, or I think is significant in terms of how people are reacting, is the fact that she glanced at Godejohn when she said, "I told him to kill my mother," in her testimony. So joining us again, Jennifer Schuster, criminal defense attorney. What do you make of those verbal clues, if anything, in terms of looking at the jurors looking at the witness or not?
You know, it's hard to say. It's always hard to predict what jurors are thinking. You know, in this case, it's interesting that they wouldn't look at the witness, but I think clearly they're looking at the defendant to see what his reaction is, and trying to gauge, you know, his level of emotion and just how he's reacting to everything that Gypsy is saying.
One of the reasons that she has a microphone in her hand, we're told, is because she wasn't speaking loudly enough, and so they had to actually give her the microphone so that her voice could be heard in the courtroom by the jury. So just a lot of different interesting dynamics. Now, Jennifer, if this were your case, would you present Gypsy's testimony as the defense at this point in time in the trial?
You know, that's a tough question, but I think ultimately I would. There are pros and cons, certainly. I mean, the fact that she's able to get on the stand and say, "It was my idea to kill my mother," I mean, that's compelling testimony. And also the fact that she's talking about all of the abuse she suffered, that's compelling. And that helps, I think, the jurors sympathize somewhat with the defendant. But it doesn't exculpate him. It's not a reason to go ahead and kill Dee Dee Blanchard. It doesn't give him a free pass. I think also she's able to speak to some of the childlike elements of their relationship. She's talked about how they had this fantasy game, how they went to the Cinderella movie. And that's been something the defense has raised, that being on the autism spectrum, he had a lower mental capacity and just really couldn't appreciate the seriousness of this crime, or there was some diminished capacity to the extent that he didn't understand the gravity. You know, on the other hand, he's allegedly able to appreciate the gravity of this abuse and appreciate how serious that was, but he doesn't know the difference between right and wrong. You know, that's a little bit of a tough argument to make, I think.
And again, if we look at the Missouri law, it specifically states for the charge of murder in the first degree that a person can be found guilty if he or she knowingly causes the death of another person upon deliberation. So from my perspective, it's pretty straightforward, not for the penalty and because he is an autistic person, some of those factors, but he did knowingly cause the death. There's no disagreement that he did stab Dee Dee Blanchard, the mother of his girlfriend Gypsy, and whether or not he deliberated may be up for debate. But to me, it's a very straightforward definition of murder in the first degree. What would your response be?
Yeah, it is. And, you know, interestingly, on the point of deliberation, the defense is actually, I think, pointing to things that show deliberation. They're talking about the length of this relationship, the fact that they talked about killing her a year in advance before it actually happened, the fact that she gave him allegedly every detail of this abuse. I mean, to me, that points to deliberation.
Right. It's really a fascinating trial. So again, breaking news, they came back in the courtroom, which you could see on the feed that we had, and now the jurors and everyone in the court has now exited the courtroom again, so, or at least the jury. We don't know why, so we're going to give you an update as soon as we know, but we are going to listen now to some of Godejohn's pre-recorded. This was what he told when he was interrogated by the police, and remember, this happened in 2015, so this is a tape from what he told the police in 2015. Well, those of you following this trial have probably been waiting to hear Gypsy testify, because that's been one of the points of discussion. Is she going to testify or not as the girlfriend? The prosecution's theory is that she is the girlfriend, conspired with the defendant, in this case, Nicholas Godejohn, and planned to murder the mother, who no one denies that Nicholas, including himself, stabbed her to death. And so we've just heard all of the testimony. There was direct cross, redirect, recross, and so they've concluded that testimony. I'm going to bring back in Jennifer Schuster, my special guest criminal defense attorney. So clearly, I think anyone listening, following, watching this trial on Law and Crime would feel sorry for Gypsy, given all of the abuse that she has suffered at the hands of her mother. But in spite of that, did you find that her testimony is credible?
Yeah, I think so. I mean, at the very end, though, they were trying to impeach her because she was inconsistent
I can't hear her.
With her deposition versus what she was saying in court. I do think she comes off as credible in her demeanor, but I gotta say, she got smoked on the cross and she didn't even know it. And that's the most effective cross, when you're able to elicit the answers you want, but you're not attacking the witness. And this prosecution team did a great job doing that. On direct, it was all about, I was the mastermind, I was the planner. Nick didn't have anything to do with the plan. And he completely, the prosecutor, diffused all of that on cross-examination by saying, you did in fact have a plan. You called it literally plan A, B, and C. And it was Nick who said it should be a stabbing. And I'm gonna need a knife, I'm gonna need a taser, I'm gonna need tape. So he did an excellent job going in there and exactly proving the opposite of what she was saying on direct, which was that she was the one who was planning it. I mean, they very much effectively proved, I think, that in fact he had a large hand in planning this.
You know, and you picked up exactly what I picked up on in the cross, and that is the prosecution, to me, presented all the testimony to say, look, he was the mastermind. He actually planned this. Let's talk about some individual pieces of that cross-examination. So one is, and I'm looking down at my notes because I wanted to write down as the testimony was being presented, he insisted that she capitalize his name, that he would send her scripts to use, that they had role playing. They both, you know, we know about that from all the different evidence that's been presented at this point in time, but that he specifically would be the master and she was the slave. So do you think all of that cross-examine is enough to convince the jury, listen, he was the mastermind, or at a minimum, he absolutely was conspiring to kill the mother?
Yeah, at a minimum, it shows that he participated in the plan. She wasn't the one who solely orchestrated this. Even if she sent the money, even if she stole the knife and she supplied the gloves, he was there every step of the way. And in fact, he came up with a lot of these ideas and he went along with the plan very much, and in many cases actually created parts of the plan.
And one of the pieces that stuck out to me was her testimony that, in fact, there was a knife that when she stole it from Walmart, he wanted a machete. And she said, that's too big for me to steal. So instead, what I'm going to do is send you a picture and tell me if this is the knife you want. I mean, how many more details could they possibly have provided to say he was actively involved in this? So for the viewers, you can see that they've come back in the courtroom and the judge is making some comments. We are going to rejoin that. Oh, she's back on the stand. So they are going to lunch in a break. It looks like they're going to be going to lunch or taking a break. And so I'd like to continue to speak with my guest, Jennifer, about the testimony that's already been presented. Now, you know, it was tedious, but the prosecution, I agree, did a really good job at going through every single point that they could pull out of all of her prior statements and text messages to say he was actually the mastermind, or he was the one in control of the situation, not her. 2 weeks before the murder, she even said, hey, let's go back to the other plan, Plan C, about getting pregnant, that he didn't respond to. So after that was accomplished, did you notice any change in the demeanor of the defense? Remember, the defense is the one who called her as a witness for our viewers. And yet, when they had redirect examination, did you notice any change in the tone or demeanor of defense?
You know, I didn't necessarily pick up on that. I know that the defense was trying to diffuse what the prosecution had accomplished on the cross-examination and trying to redirect the needle back in the other direction and show that she really was the planner. But I don't think the defense was really effective in doing that. I think the cross was so strong that they pretty much showed he really had a big hand in planning this. I thought it was interesting how she started to cry at some points, and you know, I don't know how to interpret that. If she was crying because she was remembering how Nicholas controlled her, or if she was crying just over the whole situation. I mean, but my thought initially was that she was sort of tearing up because she was reflecting on some of the moments where he was telling her what to wear, down to the color of fingernail polish she wore.
Right. Now, Jennifer, please stay with us for more of your expert analysis for some more of the testimony. We have learned from the courtroom that they are taking a lunch break and are exiting the courtroom. So we're going to take a short break, but please come back to Law and Crime. Welcome back to Law and Crime, and wow, we had all been waiting for it, and we just heard the end of the testimony by Gypsy Blanchard. This is the defendant, Nicholas Godejohn's girlfriend, who just testified. And remember, she really has nothing to lose. She has pled to murder in the second degree. She's currently serving a 10-year sentence for that. So she's already dealt with the criminal case against her. In that respect, she really doesn't have anything to lose by what she says on the stand. I think that there are two very good pieces that have come from this testimony. I think the defense was effective in saying she was the mastermind. It was her plan. She did it. She's the one that told this plan to Nicholas and got him to go along with her. But then on prosecution cross-examination, they really brought out bits and pieces of the case which prove, hey, he was the mastermind. He had control over her, and he's the one that said, no, we're not going to go with a plan C or a plan A. We're going with the plan B, which is to murder your mother. So it's really going to be fascinating to see who else the defense calls as witnesses and whether or not the defense does call the defendant. We don't know yet. The courtroom is on break now for lunch, so there is no testimony, nothing going on at the moment. And while they're at lunch, we are going to look back at some of the testimony from yesterday. Now, remember, yesterday is when the prosecution was presenting evidence. The first one we're going to look at is the computer forensic analyst, and Mr. Costello testified as to what he found from data on four things: a laptop, the computer, and 2 cell phones.
On the that was perhaps more sophisticated or different than what a typical user would do in your experience. There was some things that were a little different.
So there were some audio difficulties and we couldn't understand what they were saying, but let's talk again about some of the evidence that he testified to yesterday. And you can see that the prosecution got it into evidence yesterday, and then it was used today by both the defense and prosecution in examining the witness, Gypsy. What I mean by that is this computer analyst not only talked about how he found them, but then he had all of the text messages between the defendant and his girlfriend. Now, the presentation could have been a little monotonous to some because he literally was reading the texts and saying, defendant, blah, 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 Gypsy, blah, blah, blah. He did that for, I think, 2 hours, so the jury had to sit and just listen to him reading all these texts. But I think you could argue that every single text was really important and really good evidence, depending on which way you want to argue it. It shows that there's, I would say, an immaturity and a real role-playing and lots of conversation between the two with intimate details of their relationship and where they'd like to take it when they see each other physically. So having said that, we're now going to go and watch some of the testimony live. Not live, I'm sorry, pre-recorded. Let's see. Instead, I would like to bring Jennifer back. She's our defense attorney who's been joining me and talking with me on these different facts and situations in this case. Talk to me again, Jennifer. Relevance. The relevance of having Gypsy testify when honestly, you know, I get that there's an argument by defense that Godejohn is not competent, capable of making the decisions, and that's going to be part of their defense. But what does her testifying as to her saying, oh, I did ABC, have to do with that defense? Link those two together for us.
Yeah, well, I think there was a missed opportunity on behalf of the defense. You know, I thought they would capitalize, for lack of a better word, more on the abuse that she suffered so we could really understand what Nicholas was thinking and why he was motivated to commit this crime. But really, I mean, they talked us through the abuse, but they didn't really get into it to the extent that I thought they would. I mean, anyone who has seen that documentary really understands the gravity of the abuse, and I'm not sure we really got that on direct. But as far as saying that she was the mastermind, you know, that was one of the major themes that they went with. But I think that that was very much torn down in the cross-examination by the prosecution when they pointed out lots of things in which Nicholas participated and many, many things that he planned.
So we are going to return to some of the pre-recorded testimony of Gypsy to hit some of those points that Jennifer just described. Well, as you can see, that was not Gypsy testifying. Instead, that was pre-recorded, and that was the judge giving Godejohn, the defendant you could see in the clip, Godejohn informing him of his right to testify or not, and then he does not have, he has the privilege to prevent self-incrimination, so he does not have to testify if he chooses not to. Now, you note that Dota John's answer was he might need more time, so he hasn't yet decided. So again, Jennifer Schuster, criminal defense attorney, how long do you think this judge is going to give him to decide definitively whether or not he's going to testify on his own behalf?
Up until the last second. I mean, he should be given all the time he needs to decide until the defense rests their case. But I sure as heck hope he doesn't testify. My goodness. Gypsy Exhibit A for why you shouldn't put somebody who's fragile and young on the stand. Obviously, it's not apples to apples here. But my goodness, if the defense is arguing, if the crux of their argument is that this young man suffers from diminished mental capacity, he is the last person you want to put on the stand. And he effectively already did testify via the police interrogations, which were recorded, and also the jailhouse interviews.
Well, devil's advocate, though, if they do put him on the stand, could that be the most effective way to show diminished capacity because of how he responds when asked questions? Yeah,
it cuts both ways. You know, and to that point, I think when we watch those videos, we see somebody who's actually speaking quite freely and doesn't seem all that impaired. I mean, that's my opinion. You know, somebody who's not an expert in mental health or the issue of autism. So, you know, it's going to be critical for them to get those experts on the stand and really explain autism and the autism spectrum. I think they're the ones to do it and not the defendant.
So strategically, as a defense attorney, I have to ask this. At what point do you decide whether or not a defendant's going to testify? Do you go into court with the strategy at the beginning of the trial and say the defendant's going to testify, or is it something that you wait to see how the evidence plays out before you decide, yes, defendant's going to testify?
You know, you always want to see how the evidence plays out, but more than 9 times out of 10, it's not a good idea to have the defendant testify. It's just too risky. And remember, the defense doesn't have the burden of proof. The prosecution does. So ultimately, in most cases, it doesn't make any sense, and it's just too risky to subject the defendant to what will most likely be a brutal cross-examination. And so I was trying to not talk, but I accidentally talked over you a little bit, because one of the things I just wanted to interrupt and say, but what some attorneys, we all struggle with as attorneys, is if you are a defense attorney, you advise your client and say, don't testify, or we recommend that you testify. But ultimately, isn't it the defendant's choice as to whether or not he is going to take the stand? Absolutely. The decision solely rests with the defendant, but it's up to the lawyers, you know, to advise the defendant what to do. You know, lots of times, though, in many cases and many issues, the defendant doesn't listen to his or her lawyer. And you're right. It'll be up to Nicholas Godejohn to decide whether or not he ultimately takes the stand. And that's going to be fascinating to hear. So again, they are on a lunch break. When they resume, Law&Crime will be returning to cover that trial live. We are going to take a short break, but please rejoin us. So again, that was Gypsy testifying, and she specifically gave examples of what he did to tell her what to do and not vice versa. So he talked about, this is how I want you dressed after the murder. I would like you to have red lipstick, red nail polish. She said, I only have pink nail polish and lip gloss, but they decided that that's what she would wear, or he decided that would be acceptable. So let's bring in our special guest again, Jennifer Schuster. Compare and contrast these two pieces of video for our viewers in terms of his story versus her story. Well, if I'm the defense lawyer on this case, I'm going to be saying, why are we talking about nail polish and lip gloss and nightgowns in the same sentence as planning a murder? That shows some diminished capacity on behalf of this young man. And likewise, during his interview, he's talking about an angel on one shoulder and a devil on the other, like those old cartoons we would see. And that, again, points to some of these childlike qualities. And I think the defense needs to get an expert on the stand ASAP to talk about autistic persons and how some of these characteristics that we're seeing in him are consistent with that. You know, it is interesting to see that she's saying that he's the one who's orchestrating a lot of this down to what she's supposed to be wearing, and he seems to be saying the opposite. But on the other hand, I mean, he's saying that there's this dark side that he started to embrace, and he realized once he walked in there was no turning back. So I think in many ways he essentially admits that he was also fully on board, notwithstanding Gypsy there, participating.
Thank you, Jennifer. And if you would stand by, we're going to resume our analysis of the testimony thus far in this case. But first, we're going to take a short break, and we'll be right back on Law and Crime.